Thank you, Madam Deputy President. Not everything we do in this place is high drama, and the operations of Parliament and the processes of managing the affairs of New South Wales often require small legislative changes. And that's exactly what we are seeing in this bill.
Order. Sorry, there's a lot of conversations happening. There's a lot of noise. Could I please ask some members to take their conversations outside? Apologies, ma'am.
Thank you. Bills of this type, housekeeping bills, are generally uncontroversial, and it befits all of us in the House to focus not on opposing everything, but ensuring the smooth running of government. With that being said, however, I note that this bill is yet another in the series of small legislative changes from what appears to be becoming a housekeeper government. We're happy to see that the government is taking care of small changes, ensuring the smooth running of New South Wales, but it would be refreshing and a sign of good government if they could lift their eyes to the bigger picture and a broader agenda, rather than proudly dusting the mantelpiece during their entire time in government. The changes within the bill which allow the LECC to apply for a digital evidence access order in connection with a search warrant bring their powers into alignment with those of ICAC, and we're happy to support this change. Similarly, the amendment to the Children Detention Centres Act of 1987 is important in that it rectifies an issue which can cause incorrect discharges. Under the proposed amendment, a juvenile offender who is being released on parole may also be the subject of early discharge provisions. The bill makes several changes to the Crimes Administration of Sentences Act of 1999. The first of these permits an inmate to request a delayed release, which typically is to allow them to arrange housing, transport, and so on. This is important because it works towards providing the best outcomes for inmates being released and thus reduces the chances of recidivism. The second change permits a governor of a prison to refuse a transfer of a prisoner from the ACT. Before the ACT had its own prison, the New South Wales Government, by arrangement, provided correctional services for the Territory. However, since the opening of the Alexander McConaughey Centre in 2008, the ACT has had its own correctional facilities, and therefore it is no longer necessary to impose a mandatory requirement upon Corrective Services New South Wales to accept a full-time detainee from the ACT into New South Wales custody. And the third change allows any person, not a victim, but who can demonstrate that their life or safety is reasonably endangered because of their connection with an offender, to be listed on the victims register as an interested person and receive the same notifications. This is an important way of providing protection to a person who might be in a situation where the offender has a history of mental harm or physical violence against the person, or where the offender had a domestic relationship with the person, or where the person was a witness in proceedings against the offender. We are happy to support all of these changes. Proposed changes to the Crimes, Domestic and Personal Violence Act of 2007 strengthen procedural protections for victims in AVOs, which again allows this important legislation to operate as best intended. There are changes within the bill to the Drug Misuse and Trafficking Act of 1985, which corrects the legislation to more accurately reflect the process of analysis and certification of drugs and other plant matter within laboratories. This is important as the certificate which is given as a result of the process is prima facie evidence for legal proceedings involving a prohibited plant or substance. We support this, as well as the change which authorises police to provide drugs to persons authorised by the Secretary of the Ministry of Health. This is simply a legislative change to empower the police to provide these substances which are not unlawful for the person to possess under the Act, providing they have authorisation from the Ministry of Health. And we also support the consequential amendment to the Medicines, Poisons and Therapeutic Goods Act of 2022, which will ensure the amendment to Section 25 in this bill carries over once the Medicines, Poisons and Therapeutics Goods Act of 2022 commences. I said earlier these housekeeping bills are uncontroversial and that it befits all of us to focus not on opposing everything but on ensuring the smooth running of government. It is also our responsibility, especially as the opposition, to be sure that the legislation passed within this House serves the people of New South Wales in the best possible manner. In this spirit, we propose an amendment in respect of the changes to the Criminal Appeal Act, which I will discuss in more detail later. Pending this amendment, we are happy to support the remainder of the bill, which otherwise contains useful legislation to keep the House of New South Wales running.
Ms Abigail Boyd.